One of the estate planning documents that we always talk to people about are power of attorneys. And a power of attorney is a document that you, if you're the person signing it, you're allowing someone to handle your affairs. These come in many many variations, but there's basically a standard one put out that the law basically lays out the terms of the power of attorney. But what you do is you name an individual or individuals to handle your affairs, and then there's, in a standard power of attorney, there are a list of powers, and the power of attorney asks you, the document asks you to identify what powers you want to give a power of attorney. So, for example, you can be very specific. You can say, I'm going to give this individual a power of attorney over my bank account. Well, that person will be allowed to then handle your bank account checks, but won't be allowed to sell your house unless you've given them the power to sell your house. Or that person may have the authority to deal with stock accounts, but unless you've given them the authority for the bank accounts, they won't have the authority. A lot of, very common that spouses give power of attorneys to each other. Years ago, we never worried about spouses giving authority to each other. Because you go into a bank, and if you were the spouse, they would let you deal with your spouse's account, or they talk to you about your spouse's account. Now with confidentiality, no one's talking to anybody without power of attorneys. As I tell people, if the cable bill is in the husband's name and the wife calls up the cable company, they're not talking to her. I'm just not going to talk to her. And people tell me that all the time. And forget the IRS dealing with individual items or something like that. I mean, and most banks will not talk to you, even though you're the spouse, if you've got something entitled to your name. So you've got, if you want your spouse to deal with things, or if if you want to handle something for your parents who are coming on in years and need some help, you need a power of attorney. I always tell people who are power of attorney, who are giving power of attorneys, that you're making it easier for people to help you. Because if you die, or I'm sorry, if you're sick and you need the help and you don't have a power of attorney, you've just made it very difficult for people to assist you in handling your affairs. Now, just a couple things. The first is if there were a certain amount of abuse relating to the power of attorney in prior years with regarding gifts. And there was a concern that there used to be kind of some general language in these power of attorneys that you could give a certain amount of gifts a year, usually tied into the gift tax annual exclusion. So it would say you can give away $10,000 a year to family and friends. Sometimes they were even more generous than that. That's been eliminated from the general power of attorney. If you want to allow your power of attorney to give gifts, either to the power of attorney himself or children or charities, then you need what's called a major gift tax rider. And major gifts are really considered anything over $500 in 1 year of gifts. And so that's a second document that you need. And the reason they were doing, the legislator did that, is there was a certain amount of abuse. And now if you've got to focus on this thing called major gifts, you have to really think about it. Do you really want your power of attorney to give away your money or to either himself or herself or family or charities or things like that? Now, if you do, there's no reason you can't do it. The big item on power of attorneys, obviously, is you have to trust your power of attorney. You have to, this person, you're allowing them, depending on what kind of powers you give them, you're allowing to act for you. And so you don't want to appoint someone that you have questions about. Unfortunately, we do have cases where children have taken advantage of parents over the years, and people have actually gone to jail for misusing power of attorneys. But one one should always note, you can always revoke a power of attorney. Just one other thing is if by some chance in order to do a power of attorney, a person has to be competent. If a person is not competent, they cannot do a power of attorney, nor can they revoke a power of attorney. Then you have to get into what they call the guardianship rules of Mental Hygiene Law, Article 81, which is a much bigger deal, which requires court approval and notices, and basically a much more complicated set. So, a much more complicated set of facts and much more expensive. Much easier to do a power of attorney when you're competent, you trust people, let them be put in a position to deal with your affairs.